On the court docket is Preston and Hales, 38-2023 DR 416. Mr. Silverman, if you and your client could take the table to my left, your right. Shockett, the other one. All right, let me set the record. We're here in the matter of Lynette Preston and Jeremy Brian Hales. This is case 38-2023 DR 416. The matters for which are on the court docket include an amended order scheduling hearing, motion for sanctions from January 19, motion in limine January 24, motion to terminate deposition February 9, motion for protective order February 16, motion to dismiss February 18, motion for sanctions February 18 as well. Each of those are in the amended order scheduling hearing. There was a prior order scheduling hearing from February 20th that included all but one of those motions. The additional one was added so we can resolve it. The case is otherwise scheduled for final hearing on Friday, March 1. Intervening and needing to be addressed also is a motion for stay of the trial court proceedings filed today's date, February 28 at 9:55 a.m. If I can, I'm going to just start on the right here. If you guys can just all identify yourselves for the record by stating your full name.
Doreen Nicholas, the Shockett Law Group counsel for Jeremy Hales.
Jeremy Hales.
May it please the court, Randy Shockett, Shockett Law Group, Trenton, Florida, on behalf of Mr. Hales.
Joshua Silverman on behalf of the petitioner, Lynette Preston.
Lynette Preston.
All right, thank you. Give me just a second. All right, it would seem prudent for the court to address the issue with regards to the motion for stay. The court has received and reviewed the motion. As I understand the motion, there is an intent to consider or to file a petition for writ of prohibition. The court docket, which I, before coming in here just a little while ago, confirmed that there are no other pleadings that were filed since, but I just want the record to be clear. Is there a writ of prohibition that's been filed?
No, Your Honor, it's being prepared.
A petition for writ of prohibition?
A petition for writ of prohibition is being prepared. It's not quite ready yet. And the rules allow this, the case law allows us to advise the court ahead of time when there's such imminence coming with the first. So that's why we do that in an exercise of caution. Mr. Silverman has agreed to it as well with the continuing the TRO.
Well, there may be consensus, but I want to hear from both counsel as to why the court should exercise discretion, because it's styled as a motion to stay, which is a proper nomenclature to use, but effectively it's also a motion to continue and delay the proceedings. And the totality of the circumstances would include, at a minimum, that the respondent has been represented by counsel for 3.5 months. For more than 2.5 of those months, he's been represented by 3 separate attorneys, 2 within the same law group, 1 from a separate law group, and has asked for a continuance and has been granted a continuance on November 29, December 1st, December 5th, January 4th, and now we're here again on a 5th motion to continue on behalf of the respondent, while at the same time the pleadings include and the history includes complaints about delay in the proceedings, among other things, and it's kind of inconsistent with asking, in effect, for another continuance. And so I
maybe heard on that point.
Yeah, I want. That's what I'm saying. I want to hear
okay.
from you on support for your motion to stay,
Absolutely.
which effectively continues the matter.
Okay, thank you, and We do disagree with the court on the characterization of how many continuances we've asked for.
Well, the
We
record is the
totally-
read, and you've got appellate review.
Right.
If the court's wrong about that,
Well, but
You've
the
got a
record
remedy.
reflects that on the 29th of November, this case started. At well, maybe 2 or 3 hours into it, the petitioner was in the middle of her case. There had to be a continuance. There had to
well,
be a continuance.
but your co-counsel represented to the court that he needed minutes to complete the entire case without additional discovery, without additional grounds for continuance, and then there were, and now 5, continuances despite those representations. And I know you take issue with the court bringing that up again, but that's the inception of the case, which would have been done by the court saying November 30, the next day at 9 a.m., we'll reconvene so that your client wouldn't have a temporary injunction necessarily hanging over his head. In fact, your co-counsel said he was so sure that with just a few minutes of time, the court would be dismissing this. And then the other side of you guys' mouth is saying, we need another 5th continuance. So I don't understand how it could have been done in minutes, but now 3.5 months later, we're at a standstill or going backwards.
If I could continue without interruption, Judge, I really want to get there like you do. I want to just tell you what there's 2 different views here. The case had to be continued. I haven't seen an official transcript, but my impression of what I saw was, and I could be corrected, but I'm pretty sure Mr. Feather had witnesses here, and he said he would like them to go out of turn because she was in the middle of her case and it may take 15 minutes. I didn't hear him say, I need 15 minutes for my entire case. I thought he wanted to just have them go out of turn. But then there was this issue, it's regretful to watch what's going on here, December 1st, December 6th, or November 30th. I don't know what happened there, but it clearly got set, but it had to be continued until the 6th. So there was no request for continuance.
I found good cause for the continuance, so I'm not,
Right,
I'm
but
not
we didn't ask.
reconsidering that. There was good cause in each of those. It was
Again, Judge,
granted.
I really would like to finish, because this is really important. No other continuance in this case. We're here almost March 1st. No other continuance of this case, and please let me finish, Judge. Nothing has been caused by us. Every single continuance in this case after December 6th has been responsibility over there. She missed her deposition on December 21st. She didn't show up for the 21st. Your Honor made a written ruling, required Mr. Hales to explain why he couldn't be there the next day. Orally, you did the same thing for her as to why we had to continue on January 4th. There's been no inquiry. Nothing's been shown why Cook's deposition was missed, why hers was missed, although you verbally asked her to do it. So we got to the 4th, and it was not because it was a bomb scare.
That's part of to address the motions that are on the court docket today.
Well, you're asking for the history of it, so I don't want to be couched that we're the ones asking for all these continuances. We are here because of the behavior over there since December 6th. No other reason. Every continuance has been forced on us. So we're not here asking for another continuance. The reason why we're asking for this today is because it would all have to be redone if the first DCA issues a writ. Why waste everyone's time? Why do it? Why not just wait? We're willing to have the injunction remain in place until the date of the final hearing. So that's to prevent work that doesn't need to be done without objection, in fact agreeing we should wait. That's the basis of the request.
Anything further?
Unless
You
the
have to
court
respond.
You can, no, it's fine.
Okay. Mr. Silverman.
Your Honor, to be clear, my client does not agree to the granting of a motion to stay these proceedings. What I have clarified for Mr. Shockett and for the court, I did reply. I know it's unusual, but given the motion was filed this morning, I felt it best to offer a reply to the court. I did send an email to Ms. Haig and copy to counsel. I don't know if that's been provided to the court, but what I can tell the court...
It is not.
What I can tell the court, my understanding is in federal court, which I don't practice in, they do a lot of advising the court by letter or email. I know it's not done in state court, but because of the late notice, that's the way I did it this morning. What I set forth in that email is that my client would not consent to a stay, but my client would consent to a continuance of all pending matters in this case, including the hearings that are set for today and the final hearing on March 1st with some caveats, and I will outline those, Your Honor. The first would be that the temporary injunction must be extended during any period of continuance and until the new final hearing date in this case. My understanding is that Mr. Shockett, on behalf of his client, agrees to that proposition. The second would be that if the First District Court of Appeal, or I guess presumably the Supreme Court, if it got that far, were to grant the petition for writ of prohibition, my understanding of the law is that a successor judge has the ability to revisit any rulings this court may have made. However, as part of her agreement to a continuance of the pending matters, my client would insist, and again, I believe there's agreement from that side of the aisle, that there would be a stipulation that the issuance of the temporary injunction will not, under any circumstances, be one of those rulings that is subject to review by a successor judge, if there is a successor judge, if a writ of prohibition were to be issued by the appellate court. Generally speaking, a party in litigation can waive any right, whether it's contractual, statutory, constitutional. There's a case directly on point. It's called Kilpatrick v. McLuth, and so essentially Mr. Hales would have to be waiving his right to have any successor judge revisit the issuance of a temporary injunction. The third would be that there would be no stay issued by this court. As I understand the rules of appellate procedure, the only stay would arise if the appellate court issues an order to show cause directed to my client to respond to the petition for writ of prohibition. That would be Florida Rule of Appellate Procedure 9.100H. And then the last thing I indicated was a caveat on my client's agreement to continue these proceedings, is that by agreeing to a continuance, my client is not, I repeat, is not waiving in any way, shape, or form any arguments she may have either in this court or in the appellate court that the petitioner's, or rather the respondent's petition for writ of prohibition is untimely or has been waived implicitly or otherwise, given the lapse of time since the court first entered an order denying a motion to disqualify the first time and the second time. So she's not waiving any of those arguments. My understanding is that Mr. Shockett and his client are in agreement with those provisions, and if that is the case, then for a variety of reasons, my client would be agreeable to continue today's hearings, to continue the March 1st hearing that's set for Friday, and to allow a reasonable period of time for Mr. Shockett and his client to file the petition for writ of prohibition with the DCA.
I agree, concur with everything was said. He can make any motions he wants up at the first. That's true. He's not waiving anything.
What about the issue of the temporary injunction not being reviewable if it's remanded back?
We'll stipulate. No, the temporary injunction will remain in place until the date of the final hearing unless this court does otherwise. We're not going to challenge it. We agree that it will be in place until the date of the final hearing, whenever that is.
And so two things on that, Your Honor. One is, I'm okay with that. That's a slight tweak to what I had set forth. The caveat I placed on my client's agreement was that any successor judge could not revisit your decision to issue the temporary. The temporary would remain in effect through the final hearing. If the first DCA, for whatever reason, denies the petition for writ of prohibition, and this, Your Honor, remains on this case, I don't think that that provision needs to remain necessarily in effect. If they file an appropriate pleading and ask you, Judge Thomas, to reconsider the temporary, I think that you should be able to do that. What I am trying to avoid, however, is a new judge coming in and vacating the temporary and potentially prejudicing my client. She's not going to agree to continuance under those circumstances.
We will stipulate that, Judge.
The second thing I would ask is that I would ask if the court is inclined to go along with the party's agreement to continue matters, that Mr. Hales be placed under oath and that the court conduct a colloquy with him so that his agreement to these provisions is placed on the record under oath.
It's fine.
So, Mr. Shockett, you wish to be heard on the issue that, in effect, Mr. Silverman is characterizing that I should effectively view the motion to stay as a motion to continue rather than a motion to stay, and in effect deny it as a motion to stay the proceedings, but to continue the evidentiary hearing scheduled for today and the final hearing scheduled for Friday.
That's not what I heard him say.
Well, that's what I heard.
I'm asking, since, again, my client will not agree to a stay, I think that has certain legal implications. My client will agree to continue everything.
Everything.
The only stay would occur if the appellate court issues an order to show cause or otherwise issues an order directing this court to stay the proceedings, is the way I interpret the rules of appellate procedure. So I have no objection to the court accepting and treating the motion for a stay as a motion for a continuance. If they want to or tennis amend that motion to be a motion for continuance, I would have no objection to that. But again, for the record, my client objects to a stay, but not a continuance.
Right, and that's why I'm raising the issue, and I initially couched the stay as effectively a continuance. Mr. Silverman is saying it ought to be amended and be handled as a motion to continue and not a stay. The stay implicates issues of jurisdiction, and I can't confer jurisdiction or provide jurisdiction, as the case may be. It's set out by rule.
But, Your Honor, you have jurisdiction during a pending petition. You have jurisdiction. That's in the motion. You have jurisdiction even if the first ECA is considering. Now, they could issue an order to show cause. That's true. But what we're saying is, and it's really substance over form, it doesn't matter what you call it. We're asking that no further proceedings, absent emergency, unforeseen things, all pending matters that are pending now, be continued until the First District Court of Appeals rules on the petition. Obviously, you have jurisdiction to hear, God forbid something happens. You still have jurisdiction during that, during a pending petition. The court loses jurisdiction during a pending appeals. That's true. Even non-final orders if they accept jurisdiction, but this is not jurisdictional. A petition for a writ of prohibition is an original proceeding in the appellate courts. It's not what we think of as an appeal. So this is necessary to some extent. But you have jurisdiction, concurrent.
So here are the totality of the circumstances that are of concern to the court. And, proceeding under 9310, the subsection A, the decision to stay is discretionary to begin with. And thus, the totality of the circumstances leading to the court's determination are relevant for any reviewing court to consider. And that would include that counsel has been representing the respondent since November 13th and continuously for nearly 3.5 months. Respondent had counsel in place within 12 days of being served. Regardless of whether you are reluctant to call them motions to continue or why they were motions to continue, nonetheless, the court found good cause on prior occasions, including November 29, December 1, December 5, January 4, and now here we are again on respondent's motions to continue. There was a hearing on November 29, at which time the respondent's counsel said the case could be concluded in minutes. The court offered the following day to bring it to a final resolution. That was denied. Counsel for the respondent represented he would be in court the following Wednesday to conclude the proceedings. He failed to appear, and instead successor counsel came in, and I started that proceeding by saying, Mr. Shockett, I'm going to give you the continuance if you need it to get prepared. Number one, because I want you to be prepared. Respondent's entitled to counsel of his choosing and to be prepared. And number two, because there was a change in circumstance in that a temporary injunction, which had previously been denied by this court, had been entered. Then we came back by agreement January 4, at which time, among other things, there was a bomb threat, which, needless to say, cleared the courtroom and thwarted the proceedings from continuing any further down the path. On that same day, we agreed to come back on January 26 for final hearing, in part due to the bomb threat. Intervening before the January 26 was the petitioner's fairly new at that time counsel's motion to continue, which was then granted, which brought us to today's date, scheduled February 28. There have been complaints and pleadings filed with the court about the length of time it's taken, and now we're asking for another continuance. And I gotta question what really is the design and the desire when it would be inconsistent to complain about the length of time and at the same time ask for a fifth continuance. Additionally, there's been criticism and complaint and in pleadings before this court about the injunctive relief that as a matter of law, if a continuance is granted under the subsection statutory section, it must be 784-0485 subsection 5A, 5B, 5C. If there's good cause, the extension of the injunction that might be in place will also stay in place. This court entered an addendum that the respondent accepted I read what I proposed as the addendum on December 6th. Counsel for the respondent said no objection. I then said, take a few minutes. I'm going to go and reduce it to writing. I'm going to hand it to you in writing. Please review it. Have your client review it. Both respondent and counsel said no objection, which is an agreement, a stipulation to those conditions. Yet, it keeps coming up in subsequent pleadings as a complaint, and I understand that because he is restrained. I then, because of the ruling on December 29th, the first appellate court ruling since the October 2021 statutory change in the language, adding 6 words, and if you read footnote number 1 of the previous DCA, second DCA opinion, it is of substance and materiality. This court modified the addendum from this court's perspective more narrowly placing the restrictions, but nonetheless there were restrictions without opposition. There was the first motion to disqualify on December 21, order denying 1226, no writ sought. There's a second motion to disqualify, February 11, order denying February 14th, no writ sought. Despite the order denying the disqualification and no writ sought, and despite the fact that the writ of prohibition is the recognized proper avenue for immediate review of whether or not disqualification is an appropriate remedy, additional motions were filed on February 16th, 2 on February 18th, 1 on February 27th, all on behalf of the respondent. Additional requests by counsel for the respondent for hearing time. The court scheduling the hearing time for today. From the court's view, contrary to 9.100, which requires a writ to be filed timely to prevent further court action. And then 1 week prior to the hearings being set on the motions that were filed after the second order denying disqualification, counsel for the respondent files a third motion to disqualify. Order issued today's date, February 28th. Now, the motion to stay amounts to saying we plan in the future when we get to it, because, and I'm not belittling the intervening other requirements that counsel has both with court and outside of court, but saying I'm going to get to it, but I need more time to get to it because I got other more important things to do than my client's cause in this case, so let's continue it again. It says that there's already been a ruling creating further grounds for disqualification, so another motion for disqualification is likely to come, or a writ, I don't know which, but you've had time to do each. The rules require it to be timely. The court's investing itself again, and you're asking for a continuance, but you don't want to call it a continuance, you want to call it a stay. And the court still, because it's effectively a continuance under 2.545E, needs to find good cause, and I'm having a hard time do so.
May I be heard, Judge?
In a second, yes, you can. The inconsistencies that have been pled and pleaded by respondents' counsel are numerous. That's part of the totality of the circumstances. Whether it's I only need a few minutes, but now we've got 3.5 months and it's not enough. Whether it's complaints about additional delays, but now we're the party seeking a 5th delay. Whether it's complaints about the injunctive relief that counsel for the respondent and the respondent himself agreed to on December 6th, and then again in January when it was amended and more narrowly focused. There are 6 pending allegations for violation of the injunction, 1 implicating this attorney of record for the respondent, case 38-2023 MM497. There have been findings about violations of the Florida Supreme Court Order AOSC 1122, the 8th Circuit Administrative Order 1.14 V2, Rule of Procedure 12.310B4, and basically I'm being asked to delay a case again because we intend in the future to take further action by filing a writ, which we didn't timely do yet, and we say that we're going to. And I'm having a hard time determining that to be good cause for another continuance, a fifth.
Okay, may I be heard?
Yes, sir.
Okay, so the timing of a writ of prohibition is when it's as soon as practicable. And Your Honor, we have a fundamental disagreement here. We feel it's very clear that when an order denying a motion to disqualify a trial court judge in this state, the law is very clear. It shouldn't take issue at all. It should simply say, and I think it's even in the bench bar handbook or the bar handbook, for the court, it says simply say it's denied as legally insufficient. When there's so much more in there, there's case law that says that creates an additional ground.
File the writ. We'd
Well,
be out of
no,
here.
that's not the remedy, Judge, because you have to give the court a chance to rule on it. So we are filing a writ now based on the first three. The problem here is the Hobson's choice, because he does have a feeling and a belief he has a right to take it up to the first. He has a right to file a motion to disqualify, and so his Hobson's choice is basically this: it's not untimely. Even the second one's not untimely. Even the first one's not untimely, given the history of this case. And we are not. This is really the second time we've asked for a continuance.
Explain what you mean to me by the first one. The
The
first
first
order
motion to disqualify.
denying disqualify was not
Around Christmas time. And we thought the case would be over January 4th. Little did we know what eventually occurred every time since then. But they keep on causing continuances, and we're getting blamed for it somehow. They're the cause ever since December 6th. So
No,
what's the
wait
problem?
a second. I want you to explain that. Mr. Shockett, I'm not cutting you off as much as I'm giving you, I'm inviting you to explain that position.
Okay.
There's an order disqualifying, you've got a remedy to seek a petition for writ. You don't, but what you're saying, I just want to make sure I'm understanding this, is that,
I have the case law.
no, it's not really case law. I'm not taking issue with the law. What you're saying is factually your determination was, if we can get to January 4 in anticipation of that being the final hearing, let's just have the judge that we move to disqualify stay on the case and hear the case?
Frankly, Judge, he changed his mind based on what happened January 4th. We seem to have a ruling saying, you know what, I required him stringently to provide proof of reason for the continuance. And you orally that day ordered her, no compliance. In fact, I have a pending motion to compel discovery that you still haven't ruled on because she failed to appear in December for the depositions that you told her I might grant fees against you. You told her to provide proof. She's provided nothing. That's still a motion that's outstanding.
I think for today,
No.
to be heard.
No, it was filed, it was not filed for today. It wasn't, it still hasn't been ruled on because we're still waiting for her to comply with your oral ruling to provide proof of why she didn't show up December 21st. We've seen nothing. So every continuance is because of that. We don't want to pin it. I understand you, but we're given a Hobson's choice, which is basically have this temporary injunction continue to exist, or have this trial exist when we have discoveries issues and we have a court which he feels is not able to be impartial. So this is the Hobson's choice. He's accepted the other end of it, which is, okay, we'll have the temporary injunction. Let's see what the first says. We have agreement on both sides on this. It doesn't.
Well, there's not agreement. You
Yes.
want a motion for stay, he wants a motion for continuance.
That's a term of art, Judge. It's the same effect. The
And-
same effective remedy is you have jurisdiction. Nobody here, we want to continue the pending motions, including my motion for fees, which hasn't been noticed. I've asked, again, that's hanging since December. We want to, you have jurisdiction. Everything, any concerns you may have about what happens to her is still sufficient. The only violence that's happened in this case, Judge, is that the victim's advocate of this court's son attacked him at the barbecues in Chiefland. And there's a case on that. That's the only violence that's
How do
occurred
I-
because
how
of the
do I
case
know?
to him, not to her.
No, but, Mr. Hales, I know you're making a face. How do I know that, unless your attorney just told me it about 14 seconds ago? You don't have to answer that, but I'm just, how do I know that? Is it pled in this case?
No, it's a criminal.
Should it be? Probably not.
There's a criminal investigation going on.
A separate criminal proceeding for
Yes.
which this court, has pending, how many thousands of cases in
Yeah.
this jurisdiction?
Understood, Judge.
So,
I'm
all right, so tell me about that. I'm giving you an opportunity, your client's laughing at it, I'm asking you to explain to the court what the premise is that should be relevant.
Well, the
There are
premise is the
6
only person who can-
allegations of violations of this court's order. You're saying Judge, there's also something more important, another, maybe not more important, wasn't your words, but an act of violence
Yes.
perpetrated upon someone.
Yes.
But how am I to know about that?
I don't know. I'm telling you now, that's what happened. I didn't know if you knew, but...
don't
Okay, it's a
know.
Miss Martin who works in this building. It's her son that assaulted and battered him. There's a case. It's an ongoing case that happened 10 days ago or 8 days ago.
Your Honor, I was looking for an opportunity to jump
I didn't
in.
want- I need to go into
I'm
this.
by objecting to any discussion. This is being completely irrelevant to this case. I have no idea what that's all about, this allegation with somebody named Martin.
Well, I'm taking it in the context of, as time goes on, it's not favoring Mr. Hales by any means.
But yet, he's
That's
still
what I'm
willing
hearing,
to,
but-
he's still willing to be enjoined until the final hearing, whatever we call it, and have these other matters not be heard. Maybe it'll be heard by Your Honor. That'd be great, but just not now. We are going to file this petition as an officer of the court. It's almost ready, to be honest with you. We've been working on it, and we had to come here today. It may be filed tomorrow or Friday. She has to leave out of town Friday, so...
That's part of the court's consideration, which
Yeah.
is, if it's denied, you're still not denied. I'm not going to deny Mr. Hale's appellate review or any reviewing court to review anything that's transpired thus far for which they have jurisdiction. A denial of a motion for stay does not deny you from filing a petition for writ.
Of course, but we're just asking to keep judicial economy. Why would we want to do all this and then have it redone potentially? He's willing to accept the temporary injunction.
I've just given a laundry list of reasons
But
that...
he's not objecting. He's being hurt, and he's not objecting. And they don't object.
Your Honor, from my client's perspective, and again, I don't think these arguments are right at this point. I think that Mr. Hales probably has waived his right to seek review of the first order seeking disqualification, or denying disqualification, and the second, because there have been substantive proceedings in this case since then.
That's not even for Your Honor to consider. That's for
Again,
the
it's not
first.
right before the court today. The point I was trying to make, and it's a point that I think is helpful to you and your client's position, so I'd like to make it, is that the court did enter a third order today denying the third motion to disqualify. I don't think there's a reasonable argument that they could have filed a writ of prohibition on that third one between the time you entered that order about 10 o'clock this morning and now. My client's position, we are in agreement as to what we think the court ought to do today, whether we're calling it continuance or stay. I think I hear them saying stay, or continuance rather, but we're in agreement, and we're probably in agreement for entirely different reasons from each side. From my client's perspective, one of the reasons, and this I think goes to good cause, Your Honor, is that no matter what this court does, no matter what you do, they're going to file motions to disqualify. In our view, on this side of the aisle, there is absolute benefit in having the DCA rule on their arguments that your orders were too detailed or that they were wrongfully denying their motions to disqualify. And perhaps that can put a stop to some of this going forward. My client obviously would receive the protection of the temporary injunction. Yes, Mr. Hales would be subject to the injunction, but one, he's agreeing to it, and two, he is all over YouTube repeatedly saying that he doesn't care about the temporary injunction, it doesn't really affect him. I mean, that's not before the court today, but that is up there on YouTube. And so in light of all that...
Wait a second. It's not before the court because there's no pleading or
Correct.
evidentiary basis for it, but you're putting it before the court while you're saying it's not, which is like a
just by way of
passive-aggressive way of saying it's now before the court, but don't consider it, so...
It's by way of proffer, and
Okay.
certainly if the court wanted me to take evidence on that, I could call Mr. Hales as a witness and ask him whether he said that on his YouTube channel. But again, it's really a moot point because he's agreeing to the extension of the temporary.
Right.
I absolutely understand the court's concern. There is quite a benefit in finality here. Even if this case goes up to the DCA on the writ of prohibition, this court does retain jurisdiction to enforce its own orders. The state attorney and the Levy County Sheriff's Office maintain concurrent jurisdiction to enforce this court's orders over in the other courtroom if necessary, or maybe this courtroom, I don't know where they do misdemeanors. So for a variety of reasons, but because my client believes that it would be best for the DCA to weigh in one way or the other at this point, and because there is a third order denying a motion to disqualify that was just entered today that arguably they have not had sufficient time to bring a writ of prohibition on or petition for a writ of prohibition. That's why my client's not opposing the requested continuance.
So here's the thing. Mr. Hales has not been prohibited from doing certain things on YouTube. He has been prohibited from doing other things consistent with the Second District Court of Appeals opinion that was issued on December 29th. I literally adopted their reasoning and put it into this court's order because that's the current status of the law, because there was no other District Court of Appeals opinion since October 21's legislative change in the statute. That's as far as that goes. And I know the phrase that you just used, which is, we're in agreement as to the result, but maybe from different perspectives. I don't think the court is that far off from your all's perspective, but the way we get there, I differ from, because this court believes, number one, the stay is problematic. A continuance without good cause is improper. Yet, if the motion that's before this court is denied, Mr. Hale still has the opportunity, and I know it puts you up against a time crunch, but he still has the opportunity before Friday to file a writ, and this court's divested of jurisdiction. He's protected, his interests are protected, and we get the review.
I don't believe procedurally that's the way it works, Your Honor. I think they have to file for the writ, and it's not like an appeal, because this is directed toward the court's jurisdiction. My understanding of the appellate law is that it doesn't divest this court of jurisdiction.
To hear a final hearing?
To hear a
That'll
final-
have to be
Yes,
redone?
that's right, Judge.
Under
Because it's an original
9.1008.
proceeding. It's
Hang
not
on,
an
hang on,
appeal.
I'm gonna come to you,
Under
sir.
9.100H, unless the first DCA issues an order to show cause directed to my client to respond to the petition for writ of prohibition, there is no stay in this court, automatic or otherwise. The only automatic stay comes if they issue that order to show cause. Today is Wednesday afternoon. If they even were to file the writ today, it's the petition for the writ today, it's doubtful that the appellate court would even be able to look at it before Friday.
Well,
There's no
let me help you.
There's no automatic stay as far as I'm aware.
There's no automatic stay when you have an original proceeding in an appellate court in Florida. However, when you go to file it, it does recognize it. If anyone's ever filed one, it asks about, are there any emergent deadlines that this court of appeal has to know about? And that's where you put in, there's a trial date, things like that on this date, and that gets their attention when you have it 1 or 2 days. What we're trying to do is avoid all that and just say, because there's no, I heard Your Honor say that if we did file it, you would continue the final hearing. Well, it's going to be.
Because I agree with counsel that I don't want to put either litigant or counsel for that matter through proceedings that could potentially have to be rehashed.
Right, that's
with
our
another,
position,
with a
too.
successor judge.
Yeah.
There's no sense in anybody going through that process, especially given the injunctive relief that's in place and the restrictions. And again, it's another balance, but you, on behalf of your client, are saying you're willing to accept that.
Well, we may get it done by Friday. It depends what time you have to leave
Well-
tomorrow. But the point is that it's imminent. And so.
Well, the court wants to be convinced of that.
Okay.
And so what the court can do,
Okay.
deny the continuance, subject to you all filing a petition for writ before Friday at 9 a.m. Upon the filing of the petition for writ, the court will grant the motion for continuance, and it'll be styled as a motion to continue.
On these conditions we outlined.
Correct. To delay, or it's a delay, it's a continuance, the potential likelihood, obviously, I don't think it's going to come to fruition, but I want to avoid the potential likelihood for the litigants and for counsel, if it does come to pass, which is a successor judge having to redo anything.
Can I have a word?
I'm sorry?
Can I have a word, Ms. Angeles?
Yes, if you need a minute.
Okay, it'll be done for Friday night.
Can I have a word with Mr. Shockett, please?
Sure. If you guys need, okay.
Microphone's over here.
I-
No secret, the issue I just brought up is that you indicated.
Hang on, give Mr. Shockett a chance to, okay.
Yeah, you indicated that they filed by Monday morning or Friday morning, 9 o'clock, we grant continuous, but we're all gonna be here dressed up and ready to party Monday morning, 9 o'clock.
Just at 6 a.m.
So what I asked Mr. Shockett is, how about a deadline of tomorrow evening by like 6 or 7 o'clock?
I'd rather have 6 a.m.
Midnight.
Midnight.
Please.
The oil will be burned.
Just so we know where we're supposed to be Friday morning, whether we're supposed to be here or.
If there's consensus on the time, sure.
Well, 6 a.m.
6 a.m. Friday.
I'm good with 6 a.m. on
6
Friday.
a.m.
Friday.
Friday, March 1. So here's the other issue, and again, counsel, if you all need to consult, the court, in reasonable anticipation that ultimately a continuance is granted, it has to be continued to a certain date, because otherwise Mr. Hales has a temporary injunction without an end date, which could potentially be the consequence, quite frankly, if we're calling it a continuance in deference to the first DCA, if they're going to review up until now the proceedings. It's not predictable in terms of the outcome, in terms of time frame, but if it's conditioned upon the temporary remaining through that, so that we could reboot this court or successor court, we've got to have a date. It
How
could
about a
be-
90-day status conference by Zoom? Because he's going to be out of state by then.
The problem is service if he's not
Oh, serve,
physically
okay,
here.
you're right. You have to fly. Okay, that's fine.
If he has a date, if you need to talk about, if he's got a date that he knows he would otherwise be here, and here's the thing, if we go out 90 and we get a ruling from the DCA in
Oh,
20
that's
or
silly,
30
yeah.
days, you move to advance it, we come back to court, we hold a status conference, and we agree on another date. But there's got to be a placeholder, otherwise it's really until further order of the court. And Mr. Shockett, if you want to, if you want to consider that, we can do until further order of the court, which gets us to the same place, which is upon resolution of any matters in the appellate review.
Oh, that would be fine. That would be better, rather than to play with dates, if we could do that.
Right, but I want you to discuss.
I did, I
Mr.
just
Hales.
did. He said he could come back if he had to. There's no dates that definite that he's going to be back.
So, Your Honor, I think, just so everybody is clear, that if the DCA were to deny the petition for writ of prohibition, well, either way, right, whether it's Your Honor or another judge presiding over this case, we would have to have a status for two purposes. One would be to reset all the motions that were going to be heard this afternoon.
Correct.
Because we can't advance to a final hearing without rulings on those.
Correct.
And the second would be to reset the final hearing.
Correct.
Right? Which also raises another issue, which is if they don't file by Friday morning at 6 o'clock, and we have a final hearing without the motions that are set for today being resolved, not that I'm trying to throw more of a monkey wrench into it, but
I can tell
It's
you
going to
the
be done. It's going to
Yeah,
be done.
I can tell you the consequence of that would be that we would start the proceedings on Friday with hearing the motions.
I'm okay with that.
And
You won't, it won't.
I think you all want to avoid that consequence. And so, if in fact, Mr. Hales, my inquiry, again, is not with intention that you're going to violate the terms, but just that you understand what the terms are. I'm just going to ask you a couple brief questions about moving forward, that you've got a full understanding of the consequences. All right, you solemnly swear or affirm the testimony to provide to the court will be the truth, whole truth, and nothing but the truth?
I do.
Okay, Mr. Hales, you've been present, I know, for the proceedings, you've been hearing what's going on,
Yes.
and you understand what's going on.
Yes.
With regards to whether we're calling it a continuance or stay, effectively, the case is going to be continued. It's premised upon, by 6 o'clock, Friday, March 1st, that morning, a petition seeking review in the appellate court of prior rulings of this court will be filed. Upon that filing, the final hearing for Friday that's already scheduled will be continued to a later date, that date to be determined. You understand that?
Yes.
I've expressed concern about the continuances, whether it's on you and with good cause, or on petitioner with good cause. The court has found good cause for each of those continuances. I've expressed my reluctance here today. I'm granting it based on the representations and to not deny you opportunity for review of the appellate court through the petition for writ process. We have to await that outcome. My intention would be, or my inclination would be, to await the outcome. Your attorney or the other attorney could always bring it back, because the order of continuance and the condition that the temporary injunction with the conditions that are currently in place will remain until further order of the court. The expectation is, once that court rules, we'll have a status conference, we'll regroup, we'll agree on a final date, and And again, I'll hear from you at that time, but I'm inclined at that time to then change the until further order of court to a final date, the final hearing date, so that it's really clear on everybody's part that that will be the finality. But there's a little bit of uncertainty in how long the appellate court review process may take. You understand that?
Yes.
You feel like you had an adequate opportunity to discuss with your counsel the decision here today,
Yes.
and you're willing to accept those conditions?
Yes.
Your Honor, I would ask the court to inquire specifically about the condition on my client's agreement to a continuance or delay in the proceedings, specifically that if there is a successor judge appointed in this case, if the writ of prohibition were to be issued, that Mr. Hales is waiving his right to have that successor judge readdress the issue of the temporary, and the temporary will remain in effect until the final hearing in this case.
So in effect, you'd be waiving your ability to seek a modification of that portion of the order, which would be to terminate or to exclude you from being under that temporary injunctive relief. Do you agree to that?
I did not hear you say the words until the final hearing.
Until the final hearing.
If you would please repeat that with that phrase.
Okay, hang on a second. I want to make sure that you understand it. So what's being asked is that you're waiving your ability, another judge comes in, or me, I guess, if I remain, but either way, you're waiving your ability to seek termination of the temporary injunction pending that final hearing date that's going to be set.
Yes.
I think that resolves things here for today. Madam Clerk, we're just going to do an extended injunction, same conditions. It's just going to change the language from today's date expiration to until further order of the court. And again, Mr. Hales, you could discuss this with your counsel. Until further order of the court literally means until either side brings it back. If you bring it back, we'll advise them. If they bring it back, we'll advise you. Chances are the condition precedent that's going to bring us all back to court is the district court, if that's your intent, ruling one way or the other. And then if it's up to me, we would have an expedited status conference. I have no problem having that conference in anticipation that you may not be here, of doing it sooner than later and doing it by Zoom video if it needs to be, simply to set that next date, and then we can modify the temporary injunction to a final date of that final hearing, to accommodate what really is intended to avoid what could possibly be, even though the court has a different view, but I understand there's different view from counsel, that there won't be a need to revisit and reconsider any rulings of this court, but to avoid that possibility, it's this court's finding that that would be good and sufficient cause for the remedy that we're imposing here today, which is continuing this matter subject to those conditions.
Thank you, Judge. Thank you, Your Honor.
One is, I do want to be clear that my client's agreement to a continuance under the conditions we have discussed should in no way be interpreted by this court, that side of the aisle, or anybody else, including the DCA, as any kind of concession that my client believes that the motions for disqualification had any merit. The second thing I would point out is that, just so we're all on the same page, my understanding is that if there is not a petition for writ filed with the first DCA by 6 a.m. on Friday, March 1st, that we are proceeding to first discovery matters and then an evidentiary hearing in this case on Friday, because the court's issuing a new order. I don't know whether that technically supersedes the prior notice. I don't want there to be any argument that we are not all required to be here Friday morning at 9 a.m. if that petition for writ is not filed. I want that to be clear on the record.
It's very clear, and the petition will be filed by 6 a.m. Unless absent a nuclear war or something, it will be filed.
Mr. Hales, you understand that ultimately it's another obligation you and your counsel have, everybody does, which is to be here Friday morning, but you'll know from your counsel, and they can copy you with the filing, that if by 6 a.m. that morning a petition for writ is filed, that will relieve your responsibility to be in court.
Yes.
And you can go about your business. All right, I think we've got some clarification. Let me just review this written order here.
Let me take a quick break, Judge, while we're waiting.
Yeah, we'll stand at ease. We're at 2:30. We'll just go off record for a moment.
Thank you.
All right, we're back on record. It's 2:34. Let me just bring to your attention on the addendum section, since the addendum was not part of the form and previously included language that the court typed out, but then wrote in the date of January. Let me read it to you real quick. It previously read above conditions to remain through 3/1/24 in anticipation of Friday being the final hearing. I've just delineated in there by handwriting and then signed it, second amended, until further order of the court consistent with extension of this order, today's date, 2/28/24. So the addendum likewise is continued as it's part and parcel of what's now entitled the fourth extended temporary injunction.
Okay, we got to get back to the computer, so.
Yeah. All right, so other than providing each party with a copy, is there anything further on behalf of the respondent,
No, Your Honor.
on behalf of the petitioner?
I'm going to just repeat a request I made off the record, on the record, which is I'm going to ask bailiff to have a deputy escort my client to her car once they get in the vehicle and drive away. Since there have been allegations by both sides of potential violations in and around the courthouse, I just want it to be abundantly clear there's nothing unusual going on, so.
Are we able to accommodate that? Okay.
Thank you.
All right. All right, we'll stand adjourned.